do you guys agree that it would be a good thing if we stopped using the phrase consumer welfare and we return to, as I think I've heard Carl say this several times, as Eleanor highlighted, we focused on the real question, the language in the statute, i.e. of competition, protecting competition and competitive process. And I say that because, and Luigi, just partially in answer to your question, the consumer welfare standard has a certain attraction to a certain kind of person who is hoping for a kind of certainty. And I can see, in the 70s in particular, it was a strong desire, but it really hasn't delivered that. And the phrase, I just think, is so tainted that it's impossible to drag itself away from being what it is, which is this requirement you show a large price harm in every case for consumers. And it's very hard to get away from that. I mean, Section 2, as Matt was highlighting, what if you have your average Section 2 case, let's say, kind of like Microsoft, where a big company is killing an up-and-coming nascent, a new company or they're not nascent, a coming up-and-coming. It's not clear as any consumer welfare in Microsoft was very unclear. There's no one can calculate it, no one can measure it. So the court, of course, had to just start talking about competition. And in fact, the courts have been talking about competition and protecting competition for more than 100 years. That's, sort of respond to Randy. That is the older standard. The consumer welfare is sort of like an 80s edition that made of vinyl that has kind of like some serious question as to what we should do with it. So I think, and I propose, and I hope maybe the great output of this conference would be if we do, in fact, move beyond consumer welfare standards, start talking about competition, competitive process. Some of you economists maybe don't. Yes, I think you also care about statutory intent a bit, but that is what the statute says. It's become embarrassing to have this thing. And the worst thing about it, just to continue my question, is this case-by-case idea that you're going to try to calculate this in every case when we know so many of the things that matter are immeasurable. It's Section 2 cases, employee case, all these things. It's doing more harm than good. Who disagrees with the idea we should just get past it?
Any taker?
Go ahead. Well, I'll just say something brief, I hope, which is, of course, much of this notion that we need to stick to consumer welfare because it is somewhat measurable, it focuses on output and prices that we can measure, is, I think, highly dangerous, because what we can measure is often not something we can measure. Many of the things we'd like to measure, we can't. We use proxies for them. And what we can measure is not very interesting most of the time. So I don't care.
Randy.
Yeah, so gosh, I go to teach antitrust, and I walk by the portrait of Dick Posner. And yet I would be embarrassed to say that I almost never utter the phrase consumer welfare in class. I thought what Susan said at lunch, how is competition presenting itself? Gosh, I'm good with that. We could go back to Sherman originally, full and free competition. The only caveat to that is, in that kind of competition, sometimes firms win. And as long as they compete legitimately, they're allowed to do that.
Go ahead.
Another reason to get rid of consumer welfare is just because the word consumer so falsifies our understanding of the law. It's like, Randy had this quote before from Senator Sherman's speech in favor of his bill, but I'll just read another quick, short part of that speech. It is the right of every person to work, labor, and produce in any lawful vocation and to transport his production on equal terms and conditions and under like circumstances. This is industrial liberty and lies at the foundation of the equality of all rights and freedoms. So when you call it, one of the things that happens when you call it consumer welfare is you lose all focus on yourself, your other half in which you are a producer. It's a way to establish a dictatorship over all producers, really over all of us.
Sorry, I thought that this attachment to the idea of consumer welfare standard was to create a tent in which you could be left out. so now that we've gotten rid of this limit, now he's part of the tent? Is he all equal?
He's always outside all tents, I think. Right? Is that wrong?
Eleanor.
I misunderstand?
Okay, so I agree with Tim and others who have said it's a good time to abandon the phrase consumer welfare, because it's not just about consumers and it's not just about a standard. But don't deceive yourself that it solves a problem, because it's not specified as to what is anti-competitive. So you replace it with something that's more straightforward and less misleading, but then you really have to go the next step to talk about particular standards for particular types of conduct, like, for example, monopoly, abusive dominance. And in my view, when you get there, there has been a real sharp right turn of our Supreme Court that has to be rectified in talking about what is anti-competitive, and this is mostly about the music, the not just the presumptions in the way we usually use it, but the perspective of which is better for markets, having a very strong presumption that what even monopoly firms do is right and good, or maybe a presumption, depending on the construction of the market, that goes the other way.
Thank you.
I just want Tim to get it unanimous, right? So all five of us. I also have already written about moving along from the term. I like the protecting competition standard, but that's, I think the consumer welfare standard is partly confusing because what about labor or input suppliers are not there. So, but I want to be clear. It's so important to ask, are trading parties harmed because of a loss of competition, and not lose track of that in the big yurt.
So you see, Filippo, I was right that the consumer welfare standard was dead, and now we're burying it.